ತಗೊಂಡಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮಲ್ಲಿ ನಾನು ರೊಬೋಟಿಕ್ಸ್.
ಆಡಿಯೋ
Page.
Your judgment order directed me to pay 10 lakhs with the direction to the respondent to creditor. More than 2 months, till today, madam.
What is to be done today?
Today, madam, posted for orders.
Posted for orders.
Posted for orders regarding the creditor.
Which bank is this?
This 25,
Bank.
21, 3 hours.
Bank.
Yes, yes.
Who appeared for the respondent?
Narayan, sir.
Huh?
Narayan, sir.
Inform him. No, we can't take it to because I have a full bench in the afternoon. Yes.
Page wise adjournments. Page number 2. Page number 3, CL number 6 to 13. Page number
Hmm?
8, serial number 8.
Hmm. Hmm. IA 1 of 23 for extension of time. What is that we will see? Why should we, adjourn these matters?
I have some instructions to be taken from the party. Both 1, 8 and 17 serial number. Generally, I have to take the instruction.
We'll see when the matter is called. Yes.
page, page number 4. CL number 14 to CL number 19.
Fraud melons and charge sheet has been filed yesterday. So I will produce a charge sheet copy also. And so each time can be given to us.
No further adjournments will be granted. Order dated 10/11/2025.
Because yesterday, based on my complaint, it's against the borrower as well as the bank.
No, what is the bearing of that on this case?
Because, my signature, I'm the guarantor.
Where is Mr. You appear? What do you say?
Because my submission there only based on the complaint and the charge sheet. I needed a forged document because all my signature forged.
No, what we do is when the matter reaches, we hear, we adjourn. Yes.
Page
Serial number 16 minutes.
Yes.
Serial number 16, I appear for the petitioner. Ma'am. I seek 2 weeks time minutes.
Who appears to the respondent? Have you informed the other side?
I will inform my lords.
No, I will.
There is
You have to
negotiation
inform and
for-
mention.
No, no.
Wait till your turn. Yes, next.
17,
Page
Yes.
8 may be given.
DRT matter of 2024, not even, is Mr. Vignesh Shetty?
number 17, Vignesh Shetty.
What about this? Huh? No interim order in this. Then why is it pending? And what is the purpose of this writ petition pending here? Without an interim order from 24. We will see. Yes.
Page number
19. An instruction should be taken from the party.
In you are waiting for the other matter. You can wait for this. That's what.
This is 17. A reasonable time may be granted. I have to take some instruction. I will make the appropriate submission on the next date of the 17, 19.
You have an interim order in this?
No, I.
Then from 24, why the matter is pending here? That's what I'm asking. You understand? DRT matter, 24 you file the writ petition, we are in 26, no interim
I
order.
will see that it should be closed, Your Honor, because the property is elsewhere, that is in Andhra Pradesh. And we have moved, we have requested the bank also, some instructions should be taken. That is the reason.
This is matter next week, no further adjournment shall be granted.
My lord, serial number 19, my lord,
Yes,
filing withdrawal number.
take that.
Please. Well, as against non-granting of the interim order, my lord, I approach this honorable court. Now the tribunal has granted me the interim order, my lord, matters become infructuous.
Memo is filed to withdraw the writ petition. It is stated that The Debt Recovery Tribunal in SA number 342 of 2025 has passed an interim order. Hence, this petition has become infectious, dismissed as withdrawn.
Great.
Yes.
Page number 5, serial number 20 to 26.
My lord, serial number 25, my lord.
Yes.
Arguing counsel, Mr. Rajeshwar is undergone surgery, my lord. He requested for next week, my lord.
This is matter of 2 weeks at the request of learned counsel for the petitioner. The counsel for the respondent shall be informed.
Please.
Yes,
23, my lord.
20.
Filing my memo of withdrawal.
take that.
The matter has been settled, my lord.
Memo is filing to withdraw the writ petition. It stated that the matter is settled out of court. And hence the petition has become infectious, dismissed as withdrawn. Yes, next.
Serial number 30, my lordship. Kindly
Number?
weeks time may be granted. 30,
30?
30, 30.
30.
Weeks time may be granted, my lordships. Since
Have you
senior
informed
is
the other
added-
side?
Yeah, we have informed.
Have you informed?
Yes, we have informed.
At the request of learned counsel, the petition, this is
Interim
matter
order to be extended. in the matter.
next week, and it is informed to the counsel for the respondent. He has no objection. Interim order earlier granted is extended. List this matter on the month of March.
Greatly.
Yes.
Page for orders matter, serial number 1. Dhanusham
Lord, appeal for petition.
Anupama Hegde.
Lord,
For order.
this is a matter where I challenge the sale being in violation of 26D of the SFPC Act, where Central Registry Act, which mandates, 26D of the SFPC Act mandates the registration of any secured asset with Central Registry of Secured Assets.
What is this IN number 1/23 for amendment?
Or modification of the prayer.
Challenging the business matter initiated under the clauses of the SFPC Act, one which is now submitting before the court. All those things have been challenged before the DRT. Lord, kindly go to an HLA in page number 14.
Page number?
In page number 14.
Page number 14. Yes.
Essay has been dismissed.
40 or 4?
In page number 40.
40.
40.
Hmm.
This essay has been dismissed.
So this essay,
Dismissed.
327 of 2021,
2021 dismissed. All the
on-
contentions have been.
1 minute, 13th May 2022. What was question?
Lord, what is,
Possession 32 notice.
Issued under section 13(4),
32, 34, assigned.
13(8). Hmm.
Essay has been dismissed.
Hmm.
This order was not challenged.
Hmm.
This order is challenged before this honorable court. Can you see the prayer, my lord? I am permitted to see the prayer. First prayer, page number 32.
Yes.
The issue writ of successory or either appropriately order or direction to cause the order of the honorable deputy tribunal. Karnataka Bangalore dated 13 May 2022 in essay number 327, dismissing the application of the petition or under 71 the SFPC Act. My lord, the right for them to appeal before the honorable DRT by invoking section 18 of the SFPC Act. Today they have not taken any steps. Though this honorable court refused to enter in the interim order, they were, my lord, awaiting the appeal efficacy remedy. My lord, the second prayer is that, my lord, the question in an order under section 14 of the SFPC Act. This is also adjudicated by the honorable, the tribunal. My lord, this is also we have taken the position thereafter fiscal question of the property. My lord, the third prayer is, my lord, the issue writ of successory to cause the impute sale notice dated 13/7/2022. My lord, this sale notice has become infructuous because we did not get any bid on. We have not sold the property, sell property under the sale deed. My lord, thereafter we issued one more sale notice dated 26/6/2023. My lord, under this sale notice, we sold the property through the auction conducted on 14/7/2023. And my lord, we issued a sale certificate
Dated?
dated 19/9/2023. My lord, there is no remedy before this court. My lord, the third prayer has become infructuous. The first prayer, my lord, if he has any grievances, he has to go before the honorable DRT.
Position is also delivered.
Position is also delivered. 2023, the position is also delivered. Lord, the writ is pending 2022. though this honorable court refused to grant any interim order, they have not availed of any efficacious remedy to challenge the order passed by the honorable tribunal before the honorable appellate tribunal.
My lord, with regard to the jurisdiction, my lord, kindly take a look at prayer E, my lord.
No, first of all,
Please.
auction is conducted,
Please.
property is delivered. How can the court, you have not questioned that auction that is conducted by.
But I have not been made aware of it at all, my lord. My lord, whether he is actually conducted or not, let me produce the document.
His sales certificate is dated 19/9/2023.
He says that, but I have not received anything till date. If he has, let him submit before the court.
Why, if you just keep quiet without any interim order,
Not been informed.
won't they proceed?
But I have not been informed. My lord, also, my lord, kindly note this. He is painting a picture that everything has become infructuous, my lord, but he's cleverly forgot to mention prayer E, where what I have sought is, my lord, Central Registry Security of Construction Security Interest of India. This is the registry for all secured assets. My lord, it is mandatory 26.
Where is that?
My lord,
There has been
this
single
is something, sir,
the order.
Where is it?
26, my lord, prayer E, my lord, if you lordship on to page 33.
Communication dated by the respondent number 2.
Please,
What is that
Yes,
communication?
yes, please.
Why can't it be questioned before the DRAT?
My lord, it is-
Please wait, Mr.
How
Counsel.
can, my lord, how can statutory authority?
Yes.
The record of satisfaction of that is beyond the scope of DRT, my lord, to adjudicate intercede between bank and so. But how can a DRT take?
Argue how it is wrong. You
But-
argue on the T.
E, my lord, sure.
Yes.
My lord, if your lordship's turn to.
Where is that communication?
Now, before I come to the communication, I need to bring certain documents on record.
No, let
No,
me.
I need to just draw your attention. Before let me come.
I think you please sit down. When your turn comes, you can argue. Yes,
My lordship may finally come to page 149, my lord.
yes.
My lord, what the search, my lord, indicates with CERSAI, the Central Registry of Securitizing Asset Reconstruction Security of India. This has been made mandatory.
Let's read 149. Where is 149? What it says?
My lord, so, my lord, I made a search, my lord, of all the parties of the board. My lord, there are 4 parties before the bank. My lord, there are 4 parties before. I put all the 4 names to see if this security interest was registered or not with the CERSAI. All those 4 parties, there has been, my lord, it clearly shows. Page 151, my lord. The supposed alleged subject property which they claim is registered, it says it is not registered. That itself, my lord, and my lord, what has happened is, and even notice maybe issue the respondent number 2. I made a representation to the respondent number 2. Respondent number 2 itself has stated that this property is not registered. So, my lord, if there is a clear finding, my lord, the statutory authority, whether you may make a finding, my lord, whether 26D of the SARFAESI Act, this is mandatory, directory, but the fact remains that 26D, my lord, has not been complied with, and in my submission, that is mandatory. If, my lord,
So, before questioning, filing this writ petition, what was the communication between you and the bank in this regard?
my lord, with the bank, there was no communication as such.
So you will just like that, you will file an essay, no order you get.
But
So
I made- but I-
circumventing the appellate remedy, you want to come to this court and you will come up with some for the first time.
My lord, the fact remains, my lord, is.
No,
there has
nothing,
been blatant violation of
nothing
the law.
remains. There is a procedure. Even when there is an opportunity to you, as per the procedure, you have to ask them. You don't ask them, you keep quiet. Just for the purpose of filing the writ petition to say that this particular issue cannot be decided by the DRAT, you will come before this court.
But it is not a clever way of getting around.
No,
this.
I want you to submit before the court, before questioning this before this court by way of this prayer E. Did you ask anything to the bank before this?
I've made multiple representations.
Where are they? Where are they? And where is the, and show something that it is received by the bank.
In the reply to SARFAESI notice, it says.
Please complete, let it be argued.
But in the representation on page 136, annexure K.
Page
136.
136, dated,
Page 136, annexure K.
dated
4/10/2020.
4/10?
14/10/2020. My lord, here all those properties, my lord, all my, whatever grievances of non-compliance with the statutory laws, I brought it before the court, brought it before the bank. Paragraph 4 especially, my lord, whereas the demand notice does not narrate the manner in which the immovable property is mentioned, which charged to the bank, and it is hereby stated the enforcement of security in a particular asset can only take place provided a financial institution is able to establish a security interest in that asset was created, and hence you are under obligation to send us copies of relevant documents which you hold and you have been executed.
No, that particular thing, 26G, where is it? 26G, where is it?
There are other, regarding 26D.
Wherever it is, show.
Well, that 26D, that is before filing of the SAI, we're doing a search, I noticed. That I have not, but there are various other deficiencies, my lord. My lord,
If there are various other deficiencies, there is an order by the DRT. You have questioned all this. Why did you not go before the DRT? Why should this court entertain the writ petition? What are the great circumstances that you invoke the jurisdiction on 226?
My lord, because the DRT, my lord, in blatant disregard, it does not pass a finding whether it is registered or not. It relies on incorrect documents, my lord. And the, you know, CERSA itself has stated this property is not registered. Let him show. I will show one thing.
In the facts and circumstances where much water has flown now you will get an opportunity. According to you, it is not in your notice. Question all the subsequent sale, if at all you are entitled to, before the DRT, not before.
My lord, kindly appreciate this, my lord. If it is not registered in CERSA,
DRT will decide.
26 it cannot be registered in empty format. My lord, kindly notice it. Let my lord.
I will record your submissions on.
My lord, let CERSA come and say whether it's registered or not. I made it a party.
Not required. That will be that he can say before. I'll ask the DRT to decide this also.
My lord, CERSA, a statutory authority in DRT, my lord, interstate party, interstate.
This is nothing but to drag on the proceedings.
No, it is not so, my lord.
100% it is. It's a classic case. Please come. The present writ petition is filed, seeking the following prayers. The brief facts of the case are: the petitioners have obtained the loan and created a mortgage object security interest over the vacant land belonging to petitioner number 4 on 6/10/2004. On 11/12/2014, the petitioner number 1 was sanctioned loan of 5 crores, 5 lakhs as term loan. When the account has become NPA, on 3/9/2020, a notice was issued by the respondent under section 13(2) of the Surface Act. Then on 29/9/2021, a possession notice is issued under section 13(4), read with rule 81 of the security interest enforcement rules. Then on 13/10/2021, a notice was issued under section 13(8) of the Surface Act, read with rule 86 of the security interest enforcement rules. On 2/11/2021, the petitioners have filed an application under section 17(1) of the Surface Act, challenging the proceedings that are initiated by the bank. That came to be dismissed by order dated 13th May 2022. That is questioned before this court. Land counsel appearing for the petitioner submits that the prayer to quash the communication number CERSAI/3291/2021 dated November 29, 2021 by the respondent number 1 is a pure question of law, whether that is mandatory or directory, and that cannot be decided by the debt recovery appellate tribunal. As such, they have come before this court by filing a writ petition. It is submitted that whether the secured asset is registered or not is the question, and if not, whether the proceedings can be initiated under the provisions of the Surface Act has to be decided by this court. It is submitted that though there is an alternative efficacious remedy available to the petitioner, still he can come before this court as prayer number E can alone be decided by this court, but not the debt recovery appellate tribunal. Anything else, Mr. Counsel? It can alone be decided by this court. Next, Land Counsel appearing for the respondent bank submits that. In essay also this issue was raised.
Issue was raised, my lord, and the same
Come
was
to that.
discussed in the,
It is submitted that when the petitioner has filed the essay, this issue with regard to Rule 26, what is that?
26G of
26G of the surface rules was questioned and the court and the DRT, considering all that, had dismissed the essay. It is submitted that when once the essay is dismissed, the remedy that is available to the petitioner is to approach the DRAT. But without approaching the DRAT, the present writ petition is filed. This writ petition is filed in the year 2022, and no interim orders are passed by this court. It is-
Conditional interim order was passed. A conditional interim order.
Where is that?
So it was passed on 12/8/2020.
Yes, let me just look at it. It is submitted that a conditional interim order was passed on 12/8/2022, and the same was not complied with. A conditional interim order was passed on 12/8/2022, directing the petitioner to pay an amount of rupees 50 lakhs within 2 weeks, another 50 lakhs within next 2 weeks, failing which it is open to the bank to confirm the sale itself. Learned Counsel submits that the said interim order is not complied with. Further, it is submitted that the petitioner, the prayer number C is questioning the tender cum auction sale notice dated July 16, 2022. It is submitted that they could not conduct the sale. And on 26/6/2023, auction notification
option
was issued, sale notification was issued, and on 14/7/2023, auction was conducted, and they've issued the sale certificate on 19/9/2023, and also possession was delivered to the auction purchaser. It is submitted that the petitioner has not questioned the subsequent sales, and the possession is already delivered, and at this stage, without questioning all that, the present writ petition before this court is not maintainable. It is submitted that the writ petition is liable to be dismissed. Next part. Having heard the counsels on either side, peruse the material on record. When essay number 327 of 2021 was dismissed on 13th May 2022, and all these issues with regard to section 26G was raised before the tribunal, and the tribunal has considered and dismissed the essay. The submission that issue alone has to be decided by this court, but the DRAT cannot decide the same. This court do not find any force in the submission of the land counsel for the petitioner. On a specific 60, whether it was raised by the petitioner when he has issued to his reply to 13(2) notice, the submission of the land counsel for the petitioner is that they couldn't raise that at that point of time. The The auction notice that is questioned in this writ petition, that relief has become infructuous as the respondents have not conducted auction, and subsequently the respondents have conducted auction, issued the sales certificate, and possession was also delivered. According to the petitioner, he was not, that particular aspect was not in his notice. No, nothing was communicated to him. If that is so, even that can be questioned by the petitioner before the forum which is created particularly for this, for the purpose of adjudicating the disputes under the Surface Act. Pending this writ petition, pendency of this writ petition from 2022, without assailing any of the subsequent actions of the bank, and keeping this writ petition pending is of no use to the petitioner. That apart, the petitioner have an efficacious alternative remedy before the DRAT. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy available to the petitioner. The all the issues are kept open to be decided by the appropriate forum. Yes, that any order will come.
Cell number 2,
For petitioners, my lords, a week's time may be granted. I take further instructions, my lords, on with the matter.
Maintainability of the writ petition before High Court of Karnataka. What instructions you require for that?
So,
Where is the
23
property?
We had filed it.
Property is in Bidar.
Yes, ma'am.
It has to go before the Kalburgi.
Kalburgi.
Why is it pending from 23? And you want, even today also you say you want instructions.
My lords, yesterday I had called and he's from Hyderabad.
No,
couldn't
wherever
reach
it,
him, my
no,
lords.
wherever it is, if it is not maintainable before the principal bench, it is not maintainable.
Maybe
He has to
transfer.
go there.
Yes.
Then people answer the surety, attachment of order also. And in all those things, now
It kept this side, can't go that side. And then they should do it. Last time also the same thing. They should do it, no, something with that. Yes.
23rd matter, my lord. Now you want recommend the matter again that our method
Not referring. If you want, you'll avail the remedy. Not, I will close this writ petition. It's left open to him.
That is the reason, my lords, just one day accommodation, my lords. I'll say take instructions and then take it forward. Just one day, my lords.
No, on the maintainability.
No, I concede, my lord.
No,
This
on
will
the
not- the
maintainability,
jurisdiction
how
wise will not come before
why
my
will
lords.
what instructions your client will give to you? Please tell the court. Whatever instructions they are, the order will be one and the same. Because this is not, question of law. That it is not maintainable before this court. You
Monday,
have a
my lord.
remedy.
By Monday, I should take instruction. I'll just call him or get him then. One day accommodation.
Let this matter as parted on Monday.
Please. Great.
Yes, 3.
cell number 3. Karun Bhaiya.
Petitioner, my lord. My lord, it's for non-compliance of office objection. A week time may be given, my lord.
Have you complied with the interim order?
Yes, my lord.
apart from that, the link this 44, they thought 6 months time, time is the trade week.
Page, prayer day.
Trade week. Then the respond to bank 6 months time to give the entire week of the response bank. 500 on November, it will be the 2 years.
Yes.
My lord, we have paid 25% of the amount, my lord.
Your prayer itself, yes, it's already worked out. It is, you're seeking only time for 6 months. When is this writ petition filed? In the year 2023, and you're enjoying this stay till now.
My lord, a week time may be given, my lord.
This also parted on Monday.
Cell number 4. Cell number 4. Abhijit Singh.
This pertains to my lord, the batch of liquidations when tripartite agreement is.
Hmm.
Did it add to that?
List along with that batch of matters are there as part third. List along with them.
Main matter.
4.2, yes. Next 5.
Cell number 5. Cell number 5. Sandhya Prabhu.
I prefer petitioner in this case. There's a direction on the last occasion, to the bank to come up with a breakup, this is a case where, sale proceeds, were supposed to be.
The respondent shall place before this court what is the basis for arriving at an amount of rupees 16 lakhs and odd for the expenses and that are borne by the bank in detail.
We can memo dated minute 13 number.
13?
13 number. 2011.
No. What is your response to that order?
In fact, Lord, I agree based on this one report. For the 16 lakh, Lord, the expenses which are incurred by selling the property. That is as per page number 9 of my note.
Dated?
Dated, Lord, in fact, Lord, last case, Lord, is one report directed. Lord, I am not able to place it. Lord, before that, on the placed it on 23rd November 2024, I placed a memo along with the complete details, what is the money expended.
That itself was referred, my lord, on the last occasion. That, my lord, it's not at all with the breakup, just a letter.
No, Mr. Vignesh Shetty, when an order is passed, you have to comply with it. You cannot again ask the court to look at something which has happened prior to the order. I said breakup. So the order dated 15/10/2025 shall be as per the order dated 15/10/2025, the respondent shall place before the court what are the expenses that are borne by the bank in detail. Yes, list this matter after 2 weeks.
And also, my lord, on the last occasion, second portion of the order, my lord, that the rate of interest, the balance sale proceeds, my lord, the balance sale proceeds, my lord, they're paying me they have submitted 2.75% they're giving. When they have charged me, now I don't stand as a borrower. Initially, I had borrowed, they sold my property, they got the amount.
What is the other limb of the order?
2.75%, they submitted.
give
This
that.
court, directed, for them to come up with that interest part also, they have to give an explanation.
I sold the property.
With regard to the rate of interest also, the bank shall clarify.
Please, great reference.
Yes, next.
Cell number 6.
Appearing for the petitioner, my lord.
Deepak.
My lordship prays for a time, my lordship.
No.
Kindly have it on
How
Monday,
it
my
will
lordship.
become infractious? Now you will leave the loan because he is no more. Where is that? The respondent either submitted so and so it become infractious. No. Borrower died. Then? Huh? Against the LRs.
My lordship prays for a time, my lordship. Kindly have it on Monday, my lordship. We are seeking instruction from the clients, my lordship. Petitioner, my lordship.
No, petitioner is no more.
Yes,
At
my
least you
lordship.
have that instruction.
His wife, my lordship. We are contacting her wife, my lordship. We are
Please
not.
understand this, one
Yes, ma'am.
minute. No. What is questioned in this writ petition?
Possession notice.
Position notice.
Yes,
Now
ma'am.
everything will go.
Yes, my lordship.
Position notice, everything will go.
Yes, ma'am.
They have to initiate the proceedings afresh.
Yes, ma'am.
Once they initiate the proceedings afresh, you can come before the court.
Yes, my lordship. Much senior is inconvenience today, my lordship.
Huh?
They are senior is inconvenience today, my lordship. They are.
This matter was parted on Monday.
Yes, my lordship.
Yes.
Obliged, my lordship.
Cell number 7.
Where is the counsel for the petitioner? No representation for dismissal next week. Yes.
Cell
Huh? Next week it will come. Yes.
Cell number 8. GK Shivaprakash.
For the petitioner in this case, Lordship, the matter is settled as such, the present petition may kindly be allowed to withdraw, Your Lordship.
No, just you wanted time in the
Your
morning.
Lordship, what has happened, now the client has called me. So
You
this
should
is
have,
the
when the list
latest.
has come, you should have asked the client, give a memo.
In fact, I will file the memo, Your Lordship.
Then counsel for the petitioner submits that. The dispute between the parties, the dispute is settled amicably outside the court. Hence, nothing serves for consideration and he wants to withdraw the writ petition. Dismissed as withdrawn. Yes, 9.
Serial number 9, Kalyanar.
Not appearing for the petitioner. I'm not filing the memo for withdrawal, my lord.
Take that.
Now the sale notice, the sale has already taken place, so
Memo is filed seeking to withdraw the writ petition, stating that they have questioned the sale notice and the property has already been sold. And the petition has become infractious. Memo taken on record and dismissed as infractious. Yes, next.
Serial number 10,
Petitioner, my lord, is
Ruppa.
trying to, my lord, for the
Take your
one-time settlement, my lord, lordship may kindly.
In this
20 days
case,
time, my lord.
the sale notice become infectious, so that bidder has demanded the 25% whatever he has deposited, we have returned it.
Return the amount
How's
also.
So
the
we have to
only
issue press.
thing- What is questioned in this?
He has challenged the auction sale notice. 17.
Patch the sale notice, so it is already gone.
My lord, the interim order has been
The
granted, my lord.
actual outstanding due, we'll direct them to give the details.
My lord, the
We have
interim
already
order,
given along with the statement.
this time got passed the interim order, my lord. In view of the interim order, we have deposited 6 lakhs, my lord. After the interim order, even after interim order, my lord, they have said, saying that, my lord, they have conducted the sale auction, my lord.
He says they have not conducted.
No, we have permitted to go on with the auction subject to
No,
not to
anyhow,
confirm.
whatever it is, they have given back the 25% of the money. So nothing remains. Your first prayer has become infractious. Second prayer of yours is to give the details pertaining to what is the outstanding amount.
My
No.
lord, my lord, one minute, my lord, the property is the dwelling house, my lord. They are ready to pay, my lord, entire amount, my lord. For that reason,
For
Let them approach.
we
within
will
15
approach
days.
the regional manager, my lord. Kindly, 15 days time, may be granted, my lord. We will do that.
Fine, let them approach.
Is this matter? Then we'll adjourn this matter.
No, let this man, because already once it's auctioned, property is in my possession, we are incurring expenditure every month, security charges.
My lord, my personal belongings in
That's
the
the
house,
reason.
my lord. They have locked the house, my lord. We have all the
No, you
personal.
Yes, challenged that order.
You are
WP
happy
was
about
filed.
this from 2023. With all that you are submitting now,
24, my
all
lord.
your FR number is in the year 2023.
No, my lord, 24, my lord, 24.
WPs of 24.
March 24, we have filed, my lord.
No, you are happy from last 2 years, almost.
Please, my lord.
Your property
But, my
inside
lord,
being
as per
locked
the
up.
order, my lord, we have deposited 6 lakhs, my lord. Remaining, only, my lord, we have taken 35 lakhs.
Please understand.
We
you
have
can't-
paid already 62 lakhs, my lord.
You can't tell the bank what is to be done. Whatever is their procedure.
Only
that is
15
that.
days time, my lord. We will submit, my lord. Only 15 days time, my lord, for trying for the one-time settlement, my lord.
15 days, what will happen? You tell the court, you question the sale notice, sale has not been done, that I will record. The second relief you are seeking is, what is the outstanding amount you want to know? That they have already informed you what is the outstanding amount. What is the purpose of adjourning?
My lord,
this matter?
outstanding amount, my lord. They have,
Possession is already with them, it is not with you, not that they will take possession now.
my lord, we have also filed application for redelivery, my lord, on 27/6/2024.
How can we tell them to do, redeliver the possession? Unless
Since,
and
my
until
lord,
something-
we are ready to pay, my lord, for that reason.
That you pay, I'll say, you want to approach the bank, you approach, whatever has to follow shall follow.
Till that time, my lord, your lordship may kindly, adjournment may be
What is to
done.
be done?
During the pendency of the writ petition, we will
You
approach
will
the,
approach the bank,
Please, my
till a
lord.
period of 3 weeks, the bank shall not do anything.
please, please.
The writ petition is filed, seeking the following prayer. It's a case of the petition that the petition has availed a loan of rupees 35 lakhs from 2 accounts on the respondent bank by mortgaging the 2 properties. It is a case that petitions were regular in payment of the EMI. In spite of paying the EMIs regularly, the petitioners regularly have declared the account as a non-performing asset. Thereafter, they have initiated the proceedings under the Surface Act
7/2/2020 possession was taken.
It is
Possession
stated
notice.
that, it is stated that the bank had initiated the proceedings under section 14 and an order was passed with the magistrate on 12/1/2023. Later, the petitioners have approached the DRT by filing essay number 53 of 2023. And that came to be dismissed. Came to be disposed of by what? What is the order?
Considered order 29/12/2023.
What did the DRT say?
Possession notice, it is confirmed.
It is dismissed.
Essay is dismissed.
He says disposed.
No, no.
The essay
It
is
dismissed.
53 of 2023 is dismissed by the DRT. And the petitioners have approached this court by filing WP number 7689 of 2023.
That they have challenged the magistrate order, section 14 order.
And interim order was granted, subject to petitions depositing 20% of the outstanding amount, 10% within 1 week and another 10% within 4 weeks thereafter. Pursuant to the said order, petitioners have deposited 10% of the amount. And when they approached the respondent bank to pay the another 10% of the amount as per direction to the honorable court, but the respondent bank refused to receive the same. On 29/1/2024, the petitioners made a representation that they're willing to close the account by 31/3/2024. And with that observation, the petition came to be disposed.
Practically, they are not approached thereafter. That's why we issued a sale notice dated 17th February 24.
It is the case of the petitioner that even after payment of the said amount, the respondent bank issued the auction notice, which is a sale before this sale notice, which is a sale before this court. It is submitted that an interim order
On
27th March 2024.
on 27/3/2024 was passed.
I was permitted to go on with the sale, but not to confirm sale.
The petition was directed to pay with 6 lakhs on or before 29/3/2024.
He paid it.
Even in the event if the petitioner would not deposit 6 lakhs, the bank is at liberty to take the sale to its logical conclusion. He has not deposited.
We have deposited.
No. We have
The
told
next
not
day
to
only.
confirm the sale.
Where do you get that?
The same 30th September order. He has deposited, sir.
That's not the order.
29th, my lord, we have paid the 6 lakhs, my lord, deposit, my lord, as per the order.
It is submitted that though the auction was conducted, they have given back the 25% amount that is paid by the bidder. This is contention or discontention? Contention of the petitioner. It is submitted that they have paid the amount as per the order passed by the interim order passed by the court. It is submitted that they're ready to settle the matter. And in fact, they are approaching the bank for a one-time settlement. Land counsel submits that a reasonable time may be granted to the petitioner to pay the amount. Next paragraph. Land counsel appearing with the respondent bank submits that though they have conducted the auction, later the 25% amount is returned to the bidder. It is submitted that the two prayers that are sought, one is questioning the auction sale. Now as they have given back the amount, nothing remains to be adjudicated as far as that prayer is concerned. And the second prayer is to give the details pertaining to what is the outstanding amount, which they have already given. It is submitted that the bank has taken possession of the property long back. When?
It is 2000, December, I mean, February 2024.
In the year 2024, and they are incurring a lot of expenses for maintaining the
Security.
property. It is, land counsel submits that nothing remains to be adjudicated in this petition. If the petitioner wants to avail he wants to pay the money under the one-time settlement, it is always open to the petitioner to approach the bank, and nothing survives for consideration in this writ petition. Next paragraph, having heard the counsels on either side, there is a material not record. The two prayers, the prayers that are sought before the court. One is with regard to the auction, questioning the auction notice, and the second is with regard to the details pertaining to what is the outstanding amount. As they have not as the auction was not taken to a logical end, they've already returned the amount that is being paid. So nothing, the sale notice, that prayer has become infractious. With regard to the second prayer, already the details are furnished to the petitioner by the bank, that also become infractious. So nothing remains to be adjudicated in this writ petition. Next, coming to the other submission that is ready for a one-time settlement, it is between the petitioner and the bank. And if it is acceptable for the bank, the petitioner can avail the said remedy. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty. The reliefs that are sought by the petitioner have become infractious, number one. Number two, the writ petition is disposed of, giving liberty to the petitioner to approach the bank for one-time settlement. And for a period of 3 weeks from today, the bank shall not take any other coercive steps. Later, if that one, after 3 weeks, if nothing fructifies with regard to the one-time settlement, the bank is at liberty to take appropriate steps.
Cell number 11, Mohammed Tahir, for petitioner Shashidhar.
This is the household property of 500 square feet. Loan is 7 lakh rupees, 7.5 lakh rupees we have received. Lordship,
What is the outstanding amount as of now?
Lordship, they have not given any detail, Lordship. So far, they have not given any
What is the
details.
outstanding amount?
My lord, I pray for 2 weeks' time to file objections.
Lordship, this 2024, several times they remain absent. Even they never replied us. What happened is September, November, they have sent a notice to us, intimation notice that.
It's coming up for the second time. We will give them one opportunity. The respondent shall file their objections.
Lordship, we are ready to pay the entire money, but what has happened, Lordship, they have transferred their this loan account to ARC, Lordship. And we came to know in November. When we approached them, they said they had no.
This is matter on 2nd of February. By that time, the respondent shall file
Lordship,
their
stay may be granted, Lordship.
objections.
We are ready to pay the amount as per the Lordship, whatever amount Lordship will submit, I'll pay. 7 lakh 10,000 they are
Find
saying.
out from your client what is the outstanding amount.
Yes, my lord, we're awaiting the loan documents and inspection documents.
15/6/2024, we had given the reply to them. So far, they have not even responded.
Please understand, call your client, find out what is the outstanding amount.
Yes, ma'am.
If you find out, we'll ask them to pay, he's ready to pay. On that, we will grant stay.
Yes, ma'am.
So that you will get the money, he'll get the stay.
Yes, ma'am.
Find out. Before the court raises, you come, whenever you get the information, tell the court officer, this will be called. Yes.
Deeply
Cell number 12, Muralidhar HM, for petitioner Satish V.
Appear for the petition.
For respondent number 1, sir. My lord, aggrieved by the order, interim order, we had preferred a writ appeal date, writ appeal number 1688 of 2024. It's pending before court number 1. And stay also has been granted on 6/3/2025.
What is granted?
Stay also has been
Three
granted.
of this, so
Interim order-
vacate doesn't
Yes,
survive
ma'am.
for consultation.
It's pending still, my lord. The next date of that writ appeal is 10th of February of this.
Writ appeal number?
1688 of 2024, my lord.
88 of 2024. When counsel appearing for this respondent bank submits that against interim order granted by this court, by the coordinate bench of this court, they have preferred writ appeal number 1688 of 2024, and all in the writ appeal stay is granted, and the matter is coming up on
10th of February 2025.
10 February 2026. This is matter in the month
This
of March.
petition can be disposed of on merits, my lords. The writ appeal is against the interim order. Nothing prevents.
You're ready to argue the main matter.
Yes.
My lord, it is pending because the single bench, the divisional bench in the court hall number 1, they also have seen that they have the alternate remedy which can be seen, and they have to approach the DRT. So we are granted the liberty to take steps for furnish steps and to respondents, all the respondents, and then the matter will be listed. My lord. If we can argue after that, my lord.
Yes, let's in the month of March. Yes, 13.
13. Basavanna KM.
Memo for withdrawal file. Where is that? Memo is filed, seeking to withdraw the petition. It is stated that they have settled the matter and the petitioner has agreed to pay
They pay the amount.
one-time settlement amount of rupees 13 lakhs to the second respondent. And in turn, the second respondent is agreed and has repossessed the property, has redelivered the property to the petitioner.
My lord, one
And
second.
also agreed to hand over the original papers.
No, 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 there is the, my lord, he is a third party.
Huh?
My lord, he is also claiming the right over the property. He has a sale deed. My lord,
You entered into agreement with him then.
my lord, he paid the money on the understanding that he paid the entire money. My lord, he told
Will
me.
give the papers to him.
We have not parted with the title deeds. My lord,
Where is the council?
my lord, that's what morning also I called. The understanding is that, my lord, as far as the title deed is concerned, he will go to the civil court. Accordingly, we have accepted the money from the petitioner.
What is happening to the banks? At least bank is expected to act in a manner
Morning
known to
of-
law. Somebody comes to you, somebody takes loan, somebody comes, you will take the money.
Yes, my
And
lord.
then you will
I
say,
agree.
as far as the papers are concerned, go to the civil
I
court.
agree,
Then
I
why do you accept the money
I
of
agree, my lord, the
a third
observation of
party?
this honorable court. That is the reason I also advised the bank, we could not have accepted the money in this matter. And the understanding
I
is
think
that
this, all this, no, which bank is this?
this Kotak Mahindra.
I think we should, this is a matter where we should call for the Reserve Bank of India to look into these affairs of the bank. Why the banks are doing all this?
My lord,
The memo of withdrawal is fine. Just extract this. The petitioner before this court is a third party. Land counsel for the respondent bank does not dispute the fact that the amounts are taken by the bank from a third party. But however, as far as returning the documents are concerned, they cannot return the documents, but it has to be, they have to get it from a civil court. This is so unfortunate that a bank, which bank is this?
Kotak Mahindra Bank.
The banks are acting in this manner and they are accepting the money from a third party and creating disputes, unnecessary litigation and disputes. The registrar, this court in the facts and circumstances, this court deems it appropriate to suo moto implead the Reserve Bank of India.
Since he is also having CLD, considering the facts and circumstances, 1340, invoking section 1340 of the Surface Act, they accepted. If such being the case, my lord, I advise the bank to return the money to.
No, but I'm telling you, if these kind of things comes, I will definitely, Canara Bank is one bank where the Reserve Bank has to look into the affairs, and this is the second bank.
Pardon in this matter. I advise the bank also in this matter.
What did you say?
Post the matter on next week.
No, that you away. The bank shall come up before this, the respondent bank shall file an affidavit before this court. How they have accepted the money from a third party and why they are submitting before the court that they will take the money, they will accept the money from a third party, but they will not give the documents to a third party. In that case, why should they accept the money? In this regard, an affidavit shall be filed by the bank by the next date of hearing. List this matter as parted. Don't give the date now.
Cell number 14. Cell number 14.
Hearing for petitioner.
Rakshit Kumar.
I sought time for a week's time here to produce the milords.
Let's see what it is.
Here, milords, the petitioner before this court.
What is the prayer in this writ petition?
My lord's prayer is to, my lords, I filed an application for amendment of the prayer because, my lords, when the writ petition was pending, my lords, I may bring the facts of the case, my lords. My lords,
1 minute.
please.
Impugned order dated 31 passed by the debt recovery tribunal. Against order of the debt recovery tribunal, you are before this court.
Please.
We filed written statement along with documents in support of this case in OA number.
Please, my lord. That was my return statement was not accepted, my lords, and my rejected. And I challenge that order before this honorable court. When the writ petition was pending, my lords, even the final order was also passed against the respondents therein, defendants therein.
Now,
for that.
please tell one thing. In the morning, you are mentioning about the criminal cases.
Please.
What is the bearing of it in this on this writ
Here,
petition?
my contention is, my lords, the term loan which they have extended to the defendant number 1, the borrower, doesn't have been guaranteed surety. I was not the surety to those loans. My signatures have been forged. When I received the documents, all my signatures were forged. Immediately, my lords, I filed a complaint before the jurisdictional police in Mudabidri police station. And now, after investigation, my lords, against the bank manager and the borrower.
Was it your case before this court also? Let us
Please,
see what
please,
are the,
please,
what
my
are the
lords.
facts you have stated.
Please, my lords. My lords, may I bring some facts, my lords, like before that, my lords.
Some facts as stated in this.
Please, my lords. My lords, the ASREC is a assigned company, my lords, to recover the money dues to the Bharat Cooperative Bank. My lords, respondent number 2 herein was the borrower before the
Yes,
bank.
this is matter after 2 weeks.
Great.
Yes, 15.
Cell number 10, 15.
Memo for withdrawal, my lords.
Take that.
Lords, the respondent bank has regularized the petitioner's loan account, my lords. In that view, my lords, the
MMO is seeking to withdraw the writ petition that the bank has regularized the loan account of the petitioner. Hence, this writ petition has become infructuous. Memo is taken on record and dismissed as withdrawn.
grateful.
Next.
Cell number 16.
16.
Paper for the petitioner, my lords. It's a negotiation for settlement, my lords. 2 weeks, my lords.
My lord, this property has already been sold. Physical possession is handed over. And the sale certificate has been registered also.
Let's see what is the relief that they have sought.
This case on the note of limitation in DRT.
Which one?
DRT has been dismissed.
That is questioned before this court.
Yes, ma'am. That is what they charge me. DRT has dismissed the essay on a limitation. So we squarely covered under the Kailasam P versus Karnataka Bank. This matter falls under that. So it has to be dismissed because there is no thing to condone the delay approaching the essay.
That's when is that order? When is the judgment?
When the essay order.
No, that's why you're referring to some judgment.
This is the.
In W3.
This is the 2025 February.
By whom?
By the division bench of this court.
I think we have seen this, like the consideration. I think this was argued. This is argued, isn't it?
Argued, but the final thing has come out like that the condonation of delay cannot be.
No, but how the court has considered. Court, while passing this order, has considered the judgment. What is that? Which doesn't lay the Bank of. No, what is that judgment? Not Bank of Baroda. That. Baleshwar Dayal. Baleshwar Dayal is on a different issue. That's what is. I think this needs to be heard then. This is matter after 2 weeks. What is that writ petition?
No, it's interim. Interim.
Yeah, that is
Not. That I have reserved that matter. Correct? We will have this matter after 2 weeks.
Let's kindly extend interim order.
Interim order only granted is extended.
Sorry, sir. Cell number 17 urgent. Cell number 18. Vinod Prasad, Vignesh Shetty for respondent.
What is this matter? Any interim order in this? No representation on behalf of the petition. Interim order also is not there. This is matter after 4 weeks.
Cell number 19 disposed. Cell number 20. Govind Raju K.
Appealing for petitioner, my lord. My lord, as per annexure A, we have petitioner.
Who appears? Not even notice is not issued. Which bank? Union Bank.
Union Bank of India.
Union Bank, you appear? Mr. Vignesh Shetty is directed to take notice on behalf of the bank. What is your contention? What is impugned before this court?
My lord, to restore the possession of.
Vacating that belongs to the petitioner concept, so and so. Why should the possession be restored?
My lord, as per annexure A, petition also already has been vacated from the property. Vacated from the scheduled property, my lord. As per annexure A, notice for vacation dated.
Let's read your what are the facts of the case. You don't question the order under 14.
My lord, we are ready to deposit 5 lakh, my lord.
No, it's not about that. How can you maintain this writ petition? You simply say, let bank give back the position to you. There are order 13-2, 13-4, 13-8, 14. There are so many proceedings that are pending, that were already initiated by the bank. You have not questioned it.
My lord, we are questioning to quash the notice, my lord, impending notice, my lord.
That
Notice
is a
of-
consequential notice after the 14 order is passed.
The petition already vacated from the property, my lord. We are ready to deposit 5 lakh within 2 days, my lord.
You are the advocate on record. Where is your senior?
He's out of station, my lord.
The petitioner, the prayer that is sought before this court as only to quash the notice dated 5/8/2025, where the petition was asked to vacate the premises. And even as per the petition, several orders or the several proceedings are initiated on the Surface Act. And even under an order under section 14 is also passed. But the petitioner has not questioned the same. At the request of the counsel representing the counsel, the petitioner, list this matter after 2 weeks. With these prayer, this writ petition cannot be, is not maintainable. Mr. Vignesh Shetty is directed to take notice, serve the papers. Counsel of the petition shall serve the copy of the writ petition on the counsel. List after 2 weeks. 21.
21 Jagadish Pachari.
Petitioner loan for the purpose of alteration of construction of for 5 lakhs 12,000. Some amount has been paid. Your lordship, position with me. Now issued 5 lakhs 33,000 rupees of I'm ready to pay some amount.
Some amount this.
Yeah, your lordship, I leave it to that.
What is the amount?
Now, as on the date of this, 5 lakhs 33,000.
5 lakhs
33,000.
is the
Loan amount, 5 lakhs 12,000.
Let's look at this order. We will find out what is that amount.
Notice will no notice.
So borrowed a loan of rupees 5,12,624 on 24/9/2023. A dues on as on 11/10/2024. The due amount is rupees 5,39,962. How much you will pay?
You are like 20% or 10 or 20%. 20%. I am ready.
I will not grant any order with 20%. First, you have to pay 50% of the amount. Remaining amount, when are you going to pay the amount?
You are last of 30%. I am ready. 30%. 30%. 30%.
And remaining amount, when will you pay?
You are like some memo for calculation, if any minute by the respondent, then
I'll say you will pay 30% amount within 1 week from today.
Yes.
And the remaining amount within 4 weeks from today, you will file an affidavit before this court. When you are going to, that is, we are in the month of January now. You have to clear that amount by April. Then only I will grant interim order. Find out from the client. Yes, password.
Yeah, my client is in.
You can call. You can call and find out.
You are one submission. You are I am ready to pay 30% amount. You are call this case within 2 weeks. Meantime, if any agreement, I am ready to pay entire amount. 30% within 2 weeks or 3 weeks.
30% within 1 week, and the remaining amount you will be paying it by April. That's what is it. If that is your submission, I will grant an interim order.
Otherwise,
April is 3 months.
Both are brother and sister constructed house. Alteration of obtained this loan for the purpose of alteration of constructed house. Brother and sister staying with us.
If it is brother and sister.
I am now at present 30%. I am ready to pay.
Then counsel for the petitioner submits that the amount, outstanding amount is 5,39,000 and odd. It is submitted that in fact the petitioners want to clear the entire amount. And they will come up with an affidavit before this court within what time they are going to repay the amount. Considering the same, they shall be stay of all further proceedings on the condition that they shall deposit 30% of the amount within 10 days from today. If the petitioner fails to pay the 30% of the amount within 10 days from today, the stay granted by this court stands vacated without further reference to the court. An affidavit, undertaking affidavit shall be filed with regard to the remaining payment by 2nd of February, or else even if affidavit is not filed, even on that ground, the stay granted by the court stands vacated. Notice to the respondent.
Cell number 22. Adinath Nade, a petitioner. Francis Xavier.
Yes.
In this case, my lord, a loan of 30 lakhs was taken for the home loan, my lord.
Now let's see what's the prayer.
There is page 8.
Consider the vote
To consider the representation.
You know, we can't,
No,
in accordance with.
No, I will submit, my lord. 30 lakhs is the loan. No, I will submit what has transpired. How much I
whatever
paid.
has- Before that, I will definitely let you make your submission.
Recently, I paid 30 lakhs, my lord, by the
Whatever you have paid.
order of this court, my lord.
Whatever you have paid, the manner in which this prayer is framed, if they will do, if it is acceptable, if there is a procedure, there is a scheme, they will do it.
The second
In the
prayer
light
is
of the
my lord.
settled law, there can't be any direction to the bank to,
Your lordship may kindly
consider
see-
it under OTS.
Your lordship may kindly see the last time order. Last time order for a second. After it was brought to the court's knowledge, court directed me to pay 15 lakhs in the initial stage, which I paid. Last occasion, your lordship may kindly see the order. That is on 37/2025.
That's a whole difficulty. You have to understand the.
No, what I'm submitting.
difficulty of the court.
No, my lord, may I submit, my lord? The amount was total 50 lakhs. I already paid earlier 15, now 30, that is the total amount. Now they have come with a new figure, 83 lakhs. How did they arrive at that? They are not giving me any split out. I've taken only 30 lakh rupees loan, and earlier I paid 17, now 15, now 30. Let them at least give me, how did they're just putting interest on interest. They're not giving me any
They are
split out.
calculating interest. It has to be as per the RBI guidelines, they will do it.
No, that's why, my lord. Let them give me at least a split out, how they reached 83. I have paid it, I paid the EMI. Initially it was COVID, at the time I paid 15 lakhs. Then recently in the 7th month I paid.
That being the author, we filed OA. My lord, the third prayer to state, pass an order. To pass an order of quashing the application in OA 482 of 2022, filed by the respondent against the petitioner. If at all, my lord, their case is that the calculation is incorrect, the interest has been charged exorbitantly. Let them appear in OA, file a written statement of objection containing that the manner in which the interest is calculated is incorrect. My lord, instead of that, my lord, they approached before this honorable court on the guise of OTS. My lord, the OTS has been rejected.
When is that?
My lord, the first OTS, my lord, their contention, first prayer, kindly see the ink page number 25, Annex C. Annex C, as far as the OTS letter dated 6/3/2022 is concerned, it has been rejected. And my lord, as far as the OTS letter dated 24/3/2024 is concerned, it is also rejected by the bank.
Para 10 of my.
One second.
Sorry.
I will conclude.
Take that.
When the both OTSs were rejected by the bank, my lord.
Does she have a copy of it?
The first 5/3/2023, my lord, Annex C, she herself has produced the representation that has been rejected. And as far as 24/3/2024, that is also rejected by the bank. Lord, my lord is well aware, the Arvind Electronics judgments, my lord, the OTS is not a matter of right. My lord, it is a discretion wisdom of the bank either to accept the OTS or to reject the OTS. Under such circumstances, my lord, the petitioner cannot compel the bank to accept the OTS. As far as
What is the stage of the OA now?
the OA, since the stay has been granted, my lord, the OA is pending from 2020. My lord, if such being the case, my lord, let them appear, let them file the written statement.
We have appeared there, my
One
lord.
second.
Annexure D, your lordship, may kindly see for a moment. He is not making a fair submission. Annexure D, they themselves has accepted the OTs and they said 25 lakhs, we are ready. Annexure D, page 26. Your lordship may kindly see.
This is on 15/3/2022.
Yes, my lord. After
Now-
that,
now what-
15 lakhs,
what
30
is
lakhs.
it?
I've been paying. EMI also I'm paying. They let them give me, how did they arrive?
Understand, like pending, keeping this writ petition pending forever, and these kind of you making the stay, making the
No, let
payments.
them at least
OA
submit.
is pending, why should the OA be quashed? That I'm not able to understand.
My lord, because they have arrived at the interest which is not even admitted in the agreement.
Can't it be decided by the, this court cannot decide whether that amount, what is arrived at is correct or not.
Very well,
In the
my lord.
OA, that can't be decided?
Yes, my lord. At least let them give
That
an
they will give,
opportunity
go
to
before
me.
the OA, go before the
No, I am
tribunal.
appearing before the OA court, my
Then
lord.
why, then
But
the
this,
stay is not
but the
required.
calculation, the way it has been done,
That
my-
I'll say your contentions. and say
your
that the
lordship
bank
can
should give-
understand 30 lakhs loan, already paid 70, almost 15 and 30 and 17 lakhs. Now it is showing 83 lakhs. How did they even arrive? 30 lakh rupees is the loan, my lord.
We'll ask
It's
the-
a house, my
We'll
lord.
ask the tribunal to try to consider all these grounds that were raised by you. That's the only way this litigation can be, it can be, it will attain finality. Otherwise, it goes on like this. Please come.
Last time order, if your lordship can kindly see for a moment, my lord.
Huh?
Last time order.
I've seen that order, but you
The
understand
court-
legally,
the court
we are not,
said-
it's not
court-
permissible for the courts to
Court
do
said
all
you
this.
pay, are you ready to pay? I said the total amount
No,
is.
the court will say you pay this much. Can this court compel them to accept
No,
your
no,
amount?
No, but I'm only
OTS,
asking.
we can't compel them.
Yes, yes,
There
ma'am.
can't be a mandamus to the bank to
Yes.
accept the OTS.
Yes, ma'am. But we have approached them. They have given me one-time scheme of 25 lakhs. Now their latest one endorsement they are giving and telling we are not ready for the OTS. It is a house, my lord. It is a house. 1 minute, sir. Sir, please let me come.
To settle the account under the compromise, please come up with a proposal acceptable to the bank. They have not accepted the OTS.
Annexure D. Annexure D, I will just read. ma'am.
Annexure, our rejection letter
C, our
in page number.
C is from the bank and D is my representation. First of all, I would
No,
like
you're
to.
saying that bank accepted. Read what, basing on what you say, bank
Annexure,
has accepted.
Annexure C, man.
Read.
With reference to the letters requesting one-time settlement in respect of the above mentioned account to us. In this connection, we advise hereunder closure balance of your account as contracted, rate of interest on 69 lakhs 27,000. As the compromise amount of OTS settlement will be arranged by the sale of security charged to the bank, we cannot accede to your request for stopping the action under SURFACE already initiated. If ready, pay, settle your account under compromise. Please come up with a proposal acceptable to the bank.
For 1 minute, can you say that by this the bank has accepted your one-time settlement?
I'll just.
Bank said you come up with a proposal. Now
Yes,
you
my
have
lord.
come up with a proposal.
I give her a proposal, my lord.
Yes.
First of all-
24/3/2022. Now he has filed a memo.
Yes, ma'am.
Saying that that proposal is not acceptable to the bank. Thereafter, the petitioner submitted the representation on 24/3/2022 and the same has been rejected on 6/4/2022.
On 37/20/25, when the same submission was made before the court asked what is the total outstanding amount. I said it is 30 lakhs. They said, are you ready to pay at one stretch? I have arranged one more loan and paid this 30 lakhs now. Now they are coming and telling 83 lakhs is the thing. It is a house, my lord. It is a house. I have only that house.
I understand. What is the indulgence of the court? You please tell the court.
Please, my lord, let them give.
That we can't do it. And unnecessarily, all this kind of indulgence was not shown. Your problem would have been, you would have, everything would have been settled by this time.
No, because during the COVID time I've come, my lord. That time he couldn't pay. Still, court directed.
Now you have paid.
We
Now
have
the
paid.
OA is pending. They'll not, till the OA is decided, don't take any further steps. And with regard to that interest and all, let everything be decided by the tribunal.
Let this court direct the court to consider why that type of rate of interest has been.
Whatever it is, let all
when
the
you
things
contest-
can be. When you're contesting the OA, raise all the grounds with regard to the interest and all, how they arrived at that interest, it's their burden to tell the court, tell the tribunal. Please come.
Now, in fact, my lord, in the previous order, I clearly submitted that the outstanding is not 30 lakhs. Last paragraph is not reading the last paragraph.
Leave it. The present petition is filed, seeking the following prayer. The facts of the case are the petitioner, it's a case of the petitioner that the petitioner has availed a housing loan for a sum of rupees 30 lakhs from the State Bank of Mysore on 2/1/2014. And by mortgaging the property, house property belonging to the petitioner, dated 2/2/2014. Because of the pandemic, the petitioner could not pay the amounts. In a time-bound manner. Then the bank has declared the account of the petitioner as NPA. According to the petitioner, as on date, the filing of the petition, the petitioner has repaid an amount of rupees 17,63,093. Thereafter, the bank has initiated the proceedings by filing OA number 482 of 2020 against the petitioner and her husband before the Debtatory Tribunal at Bangalore, seeking recovery of rupees 53,96,617 with interest at the rate of 14.15% per annum. The petitioner has approached the respondent bank by representation dated 6/3/2022, seeking a one-time settlement against the loan account. The respondent number 2, the bank, by reply dated 15/3/2022, had requested the petitioner to come up with a proposal acceptable to the respondent number 2. Then the petitioner, by letter dated 24/3/2022, has submitted the proposal that the petition is ready to pay an amount of rupees 25 lakhs as one-time settlement, and the bank has not given any reply. Hence, the petitioner was constrained to come before this court. Then counsel appearing for the petitioner submits that on 21/6/2022, an order was passed directing the bank not to precipitate the recovery action against the petitioner, subject to the petitioner depositing a sum of rupees 15 lakhs within 2 weeks from the date of order and continue to pay installments, failing which the interim order would stand automatically rescinded. The said order is extended from time to time.
Can you just pass on the memo, ma'am? Memo, can I pass on? The payment's done.
1 minute. Then on 37/2025, another order was passed by a coordinate bench of this court, which reads as follows. Extract the order dated 37/2025. Then counsel appearing for the petitioner submits that so far the petitioner had paid 45 lakhs.
15 lakhs plus 30 lakhs.
45 lakhs
45 lakhs.
till today. And then when the OA was filed, the outstanding was 53 lakhs and odd. And when the matter came up on the last occasion, the then counsel for the bank has submitted that the outstanding as on today is 85,81,723. It is submitted that on what basis they have come to such conclusion. There is why they have what is the interest they have charged and how they have arrived at such amount. There is no basis for it. Till now, the petitioner is not given any breakup and how they have calculated and arrived at that amount. It is submitted that when the petitioner is ready to pay, ready for a one-time settlement, and have already paid substantial amounts, the respondent ought to have considered the case of the petitioner for the one-time settlement. Anything else? one-time settlement. Next para. Then counsel appearing for the respondent bank submits that when the matter came up on the last occasion, it is stated that the outstanding amount, the due was 85 lakh, as on date is 85 lakh 81,723, but not rupees 30 lakhs. When the bank has has filed the OA, the writ petitioner has filed this writ petition and sought stay of all further proceedings. As such, they could not proceed with the OA. What all the contentions that are raised before this court with regard to the interest or about the amounts which are without any basis, all these things can be agitated before the tribunal in the pending OA. And the petitioner, without contesting all that, cannot come before this court. It is submitted by the learned counsel, further submitted by the learned counsel that the petitioner has given a representation dated 6/3/2022, and on 15/3/2022, they have communicated to the petitioner that if the petitioner wants a one-time settlement, they should come up with a proposal which is acceptable to the bank. Then the petitioner has submitted a representation on 24/3/2022 that he is ready to pay an amount of rupees 25 lakhs. And as the same was not acceptable to the bank, it was rejected on 6/4/2022. Learned counsel, relying on the judgment of the Honorable Apex Court in
SBA versus.
Give that.
SBA.
State Bank of India versus.
Take that. Relying the judgment of the Honorable Apex Court, State Bank of India versus Arvindra Electronics Private Limited, reported in 2023 1 SCC 540. Which paragraph is that?
Para 16, my lord, 1670.
The Honorable Apex Court has held that the Honorable Apex Court, considering the judgment of the earlier judgment in Meena Agarwal's case, that is, where do you get the citation?
My lord, the Meena Agarwal's judgments, it is there, my lord.
In 2023 2 SCC 805. The Apex Court has observed that no borrower can, as a matter of right, pray for a grant for the benefit of one-time settlement scheme. No writ of mandamus can be issued by the High Court in exercise of the jurisdiction under Article 226 of the Constitution of India, directing the financial institution bank to positively grant a benefit of OTS to a borrower. The grant of benefit of OTS scheme is subject to the eligibility criteria and the guidelines issued from time to time. It is submitted that the prayer as sought for by the petitioner and the writ petition as filed is not maintainable, and the petitioner may be relegated to the OA and may be directed to contest the OA that's pending before the tribunal, and the writ petition is liable to be dismissed. Next.
It may not, they not precipitate till the OA is disposed of, man.
Huh?
They let them not precipitate till the OA is disposed of.
That's what I said.
I'll take all the contentions.
2014 law, 2014 we sanctioned the law. If such being the case, my lord, kindly direct it with the time bound and manner dispose of the OA.
I will also fix
We
a
have
time
also-
frame for the OA also.
Yes, ma'am.
Please, ma'am.
To be disposed of expeditiously.
Within a period.
The period of 3 months. The next para, having heard the counsels on either side, there is a material non-record. The first prayer that is sought by the petitioner with regard to one-time settlement, OTS, in the light of the law laid down in the judgment. In the light of the law laid down in so refers Subra, there cannot be any mandamus and such a prayer cannot be entertained by this court. Next, coming to the contention of the petitioner with regard to the exorbitant, with regard to the amount that is arrived at by the respondents. And according to the petitioner, in spite of paying an amount of rupees 45 lakhs, now again they say that the outstanding amount is 80 lakhs and odd, and there is no basis for it. The respondent, all these questions.
Sorry to interfere. 45 lakhs as on now, but as on the date of the petition, 17 lakhs is already paid. Additional to that, there's 45 lakhs. I've already stated in my petition.
Or
17
earlier
lakhs
an
is
amount
paid.
of rupees 30, 15 lakh, how much?
17 lakhs.
17 lakhs is paid and pending the writ petition 45 lakhs.
17 lakhs 63,093.
17 lakhs
Already
63,000
paid.
and odd is paid and pending writ petition, pending writ petition 45 lakhs is paid and still they say that the outstanding amount is 80 lakhs and odd. And, the respondent, all these issues can be, the petitioner is at liberty to raise all these issues before the tribunal. And the respondent bank shall also come up with their response to that. And the tribunal shall consider the OA, considering the respective contentions of both the parties. The OA is filed in the year 2020 and in view of the interim order granted by this court, the same is pending before the tribunal. Hence, considering the dispute between the parties, this court and the fact that it's a residential building, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the, requesting the DRT to dispose of the pending OA number
480. 482.
1 minute.
482 of 2020.
482 of
2020.
2020 within a period of 3 weeks from the 3 months from the date of receipt of the copy of the order till the orders were passed with the DRT in the pending OA, the respondent bank shall not take any coercive steps.
Sorry, my lord, after adjusting the 30 lakhs which they have paid after the order 31 survey, now the balance as on date is 61 lakhs 53,391.
But you said 80 lakhs.
80 lakhs as on date of passing the interim order. That interim order.
The
After that, they paid
learned counsel for the in his submissions, respondent submission that as per his latest instructions, as on today, the outstanding is
61 lakhs 53,391.
You're right. 61 lakh 53,000.
391 as on.
390. Yes.
God bless you.
Serial number 23 disposed. Serial number 24.
Yes, 24.
Parashuram AN. For the petitioner.
Yes. You're ready? It's the tripartite agreement.
Tripartite subvention scheme.
List along with that batch.
Number.
Yes.
Serial number 25 disposed. Serial number
Interim order to be
26.
continued.
Interim order earlier granted is extended. List along with the batch.
Serial number 26.
Yes, 26.
25 are urgent in the morning.
Morning, they said that the advocate has undergone operation. They have not informed, but they said that it's a proxy counsel and the advocate has undergone some surgery. That's why it's adjourned to 2 weeks. Yes, 26.
26. TG Sudha,
Yes, Mr. Vignesh Shetty, where are you?
Vignesh Shetty, for respondent.
Where is he? What is this matter about? 26?
Return the matter to Minute Bank. Return the matter to Minute Bank.
Oh, no representation on behalf of the petitioner. Interim order is there, look at it. So don't extend the interim order. This is matter after 4 weeks.
Serial number 27.
Yes, 27.
Kalleshappa.
Minutes, the interim order is not followed minutes. Interim order is passed on 8/4/24.
Let me clarify that. %, no amount is paid or some of the amount?
Some amount, my lords.
Which amount
What is paid is 1,30,000 is what is paid, my lords, but the outstanding as on today is 28.
Outstanding. When you come to the order dated 8/4/2024,
Please, my lords,
what it says is 10% of the amount shall be paid within 4 weeks. Remainder 10% shall be paid within 4 weeks. That must have been paid.
No, my lords, that amounts to almost 5 lakhs change. 10%.
20%.
20%, my lords.
Amounts to 5 lakh and all.
5 lakhs and all.
How much is paid?
1,30,000.
Then counsel, the no representation on behalf of the petitioner. Then counsel for the respondent bank submits that the interim order dated 8/4/2024 is not complied with. as per the order, 10% of the outstanding amount shall be paid within 4 weeks, and the remainder 10% shall be deposited within 4 weeks. It is submitted that the 20% of the amount comes to 5 lakh and odd, but what is deposited with the petition is 1 lakh
30,000.
1,30,000, an interim order is not complied with. Considering the submission and the fact that the interim order is not complied with, the order dated 8/4/2024 is vacated. This is matter after 4 weeks. Yes, next 28.
Serial number 28.
That appearing for petition, I'm sorry, my lord.
Check
I will grab that, but the fact is that, my lord, party is ready to deposit the entire amount. So, property has been
Who
sold.
appears for the respondent? Narayana Swamy.
On the last date of occasion, my lord, they have taken time to take instructions with regard to settling the matter, my lord, by paying the entire amount.
Where is he? Is Mr. Agni Shetty? Who is Mr. Narayana Swamy? He didn't come?
Next week.
This is matter after 2 weeks. Yes, 29.
29. Ashok
petitioner.
Patil.
For the respondent, my lord, I pray for some time to file objections. Of course, I was supposed to take instructions from the bank. My lord, they have challenged the OA order. Preliminary objection is they have to go to DRAT. But my lord, I'll place certain facts on record, file objections, my lord.
Let's just matter after 2 weeks at the request of Land Council for the bank. Next 31.
Serial number 30, urgent 31. Siddhappa BM.
Yes.
Writ petition 14211 of 23, the loan amount is fully cleared, your lordship.
What are there are 3 writ petitions. What are these?
Two writ petitions.
31, 31.1. Yes, what are they?
Lord, 31.1, my lord, the set of other loan, sale assailed before this honorable court, sale not taken place, and loan also got closed, my lord, it can be disposed of.
So 14211 of 2020. Give that file.
Oh, 2023.
14211.
2023.
Yes, 31.1.
Sale notice, my lord, challenge before this one, sale not taken place, and matter also got settled.
The writ petition 31.1. The writ petition is filed seeking the following prayer. Land Council appearing for the bank submits that the auction was not conducted and further the loan account is closed. Further loan account is closed, hence nothing survives for consideration in this writ petition. Accordingly, writ petition dismissed as instructions. Next, what about the next 31?
Petition, the loan amount was 1 crore, your lordship. The remaining balance is 77 lakhs. He's regularly paying till given the account statement also till 13 up to the recent 2026 he is paying. He needs some time, 8 weeks maybe.
I have some objection in this matter, my lord. Position notice assailed before this honorable court. My instruction, my lord, apart from my lord complying the interim order made by this honorable court on dated, my lord.
Didn't comply?
Interim order complied, but thereafter he's not paid anything. As of today, my lord, it is 77,67,000 outstanding. He's not gone and he's not paid anything. My first and foremost submission, my lord, in fact, this interim order granted, my lord, 1.5 years before. Thereafter he's not paid. Now, my lord, alternate remedy is having at the most, my lord may protect his interest for a period of 4 weeks. Let him go to DRT. 13.4 is assailed.
He's already paid in one, yes, on his moral grounds. Yes,
What is it your case that whatever is outstanding, you will pay within some time? By how much time?
8 weeks, ma'am. 8 weeks.
Undertaking affirmative file.
This matter may be called on Monday, madam. Party will be present.
Let's just matter on Monday as parted. It is Land Council appearing for the petitioner submits that he is ready to pay the, give him the accord. Land
No,
Council, the
77
respondent
lakh,
submits
my lord,
that
I have a complete, so 77 11
outstanding amount as on today is
77 lakh 67,310. I told him.
1.0, and the Land Council for the respondent submits that, petitioner submits that they are ready to pay the entire amount within a period of 4 weeks, 8 weeks, and they
Which
will
I-
file an undertaking affidavit before this court, and he seeks time till Monday.
They may consider my one time if court permits, one time.
No, ಇದು ಆಗೋದಿಲ್ಲ ಅಂತ because that is
So how
not.
many it will be, you will pay the outstanding amount, one time settlement of?
A minority institution and.
No, if it is one-time settlement, where is the question of paying the entire outstanding?
2 crores they have already cleared. Your lordship only saw 2 crores already cleared.
It's different
During
loan.
the COVID, they had not any no institution was running.
No, Mr. Shetty, how will one-time settlement and how will this OTS will go to, I mean, the paying the entire
No,
amount
no,
will go
one time
to
settlement, my lord, either it should be a scheme, or my lord, I should consider where my lord that security is less, or my lord.
Is the scheme available as on?
No, as of now, it is not there. In fact, I asked.
It's on Monday. If you want, I'll, only for that, it will list on Monday. Monday,
Grateful.
yes.
Number 30.
Serial number 29, my lord. Interim order needs to be. Serial number
Interim order
20.
is there.
Lord,
Yes.
In
interim order-
29, interim order is there.
Lord, interim order only in respect
So
of
far as the
petitioner.
petitioner is concerned.
No, whatever is interim order, that will
Yes.
be extended.
Only is petitioner.
Number 32.
As granted, interim order granted on so and so is extended. Yes.
32 Velangani, chief of petitioner.
I appear for
Lordship,
the respondent in this matter.
petitioner in this matter. My lordship, we had filed affidavit stating that we'll settle the amount for regularizing. Bank did not accept it, but there is an outstanding of 66 lakhs. When we went, they said they will take the 66 lakhs and they will close it. Now they're not taking a money since it is a pending year, and we approach for a OTS. They're coming out with different calculation. According to sale notification, 66 lakhs is a pending for us.
When was the sale notice issued?
You will be able to, I've not.
Petition is filed in the year 2025 and sale notice is dated.
The petition has become infectious since sale has not taken place. The only prayer which the petitioner has sought is setting aside the auction sale notice. And automatically the reputation has become infectious in view of auction.
Let
So
him,
with
I'll
respect
say,
to-
liberty given to him to approach for OTS.
Let him
Please,
approach.
my lord,
Whatever
they
the
are-
outstanding amount, my lord, the possession notice which is produced, it clearly
The
states.
writ petition is filed, questioning the following, seeking the following prayer. Then counsel for the respondent bank submits that they have not conducted the sale as per the notice dated 27/9/2025.
The sale has been conducted but failed.
Lordship,
They have conducted the sale, but it failed.
Failed due to
Want
want
of,
of bidders.
want of bidders. It is submitted that the relief that is sought in this writ petition has become infructuous. Then counsel for the petitioner submits that the petition is ready to pay the amount and OTS. The petitioner is at liberty to approach the bank and the bank shall consider the same in accordance with the law.
much.
Yes.
Lordship. Serial number 18, my lord. I was held up in total number 13.
Serial number
18.
What happened to that?
They adjourned for after 4 weeks. That matter is referred to Lok Adalat in the civil code which they have approached.
Yes, Mr. Vignesh Shetty.
I'll take instruction.
Will-
Lok Adalat, I don't have instruction, my lord. I'll have it after 1 week or 2 weeks.
They have filed a civil suit. Lok Adalat was
Matter after 1 week. In the meantime, let him get instructions about Lok Adalat.
much of this. There is no representation recorded.
Huh?
No representation has.
No, they'll pass 18. Land counsel for the petition submits that the matter may be referred to the Lok Adalat. Land counsel for the respondent submits that he has no instruction. Lists this matter after a week. Yes, what about that Passover matter?
Allah, Lok Adalat some time has been granted, I've been told. That's all.
What is that?
You say Lok Adalat may take time. No difficulty, my lord. We'll inform the court whether Lok Adalat is.
That is our 4 way island intimate.
Yes, yes. Next.
11 Passover.
Petitioner, Lordship. Morning senior has made submission that the petition is ready for settlement, Your Lordship, OTS. And Your Lordship has instructed the bank to get instructions, Your Lordship.
Where is that?
Don't know.
No representation for the respondent. Does this matter? Next week?
Plus date may be given, Your Lordship.
Next week on holidays, next week on 23rd.
Please, much obliged, Your Lordship.
Yes. Any signatures? Take this.
ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ
ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಜಸ್ಟ್ ಕೇಸ್ ಎರಡು ಕೇಸ್ ಇದೆ ಅದರಲ್ಲಿ ಯಾವ್ದು ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ ಇದು ಯಾವ್ದೋ ಒಂದು ಫೋಟೋ ಇದು ಬೆಳಿಗ್ಗೆ ಹಾಕಿ ಮಾಡ್ಬಿಡೋಣ
ಇಂಟ್ರಿ ಮಾಡ್ತಿದ್ದೆ ಏನು ತಲೆ ಕೆಡ್ಸ್ಕೊಳ್ತೀನಿ
ಅದರಲ್ಲಿ ಎರಡು ಬೇಸ್ ಕೇಸ್ ಇದೆ
ಇಂಟ್ರಿ ಮಾಡರ್ ಪ್ರಕಾರ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಜೊತೆ ಟ್ಯಾಗ್ ಆಗಿತ್ತು ನಿಮಿಷಕ್ಕೆ.
ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಅಂದಿಯಾರ ಮೇಡಮ್, ಪೆಂಡಿಂಗ್ ಅಂದಿಯಾರ ನೋಡಿ. ಡಿಸ್ಪೋಸ್ಡ್.
ಟೂ 2061 ಇದೆಯಾ ನೋಡಿ ಇವತ್ತಿನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಹಾ ಸರ್ ನೋಡ್ತೀನಿ, ನಾನು ನೋಡ್ತೀನಿ ಬಿಡಿ, ಈಸಿ ನೋಡಕ್ಕೆ.
ಇವಾಗ ಎಕ್ಸ್ಟೆಂಡೆಡ್. SMC ಹತ್ರ ಇದೆ ಫೈಲ್, ಅದ ಅಲ್ಲಿ ತರ್ಸ್ಕೊಂಬಿಡಿ. ಅವ್ರಿಗೆ ಬೇರೆ ಡೇಟ್ ಆಗಿತ್ತು, 2/2 ಆಗಿತ್ತಲ್ಲ, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ 11 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಇವ್ರಿಗೆ ಆಗ ಆಯ್ತು 18 ಒಂದು 1 ವೀಕ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಬೇರೆ ಆರ್ಡರ್ ಬೇರೆ ಆಗಿದೆ, ಅದು ಏನೂ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ. ಇದು ಫೈಲು 8194 ಮೇಲೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಮೇಡಮ್. ಈಗ ಹಾಕೋರ್ ಕೆಳಗಡೆಗೆ. ನೀವು ಅದನ್ನೇ ತಾನೇ ಯಾವ್ದು ಹುಡುಕ್ತಿದ್ದೀರಿ ನೋಡಿ. ಹಾ ಇಲ್ಲಿದೆ. $8194 ಅಲ್ವಾ ಸರ್? ಅಲ್ಲಿ ಜಡ್ಮೆಂಟು ಏನೋ ಎಲ್ಲ ಕೊಟ್ಟಿಯಾರಲ್ಲ, ಎಲ್ಲ ಇವಾಗ ತೆಗೆದಾಕ. ಇದು ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಇದು ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಬಿಲ್ ಆಫ್ 194. ಅದು ಅಲ್ಲೊಂದು ದಾರ ಇದೆಯಾ ನೋಡಿ ಸರ್, ಕೊಡಿ ನಿಮ್ಮ ಕೈಲಿರೋದು ಎಕ್ಸ್ಟ್ರಾನಾ ಅದ್ರದ್ದ. ಇದು ಸಂತೋಷ್, ಅದೇ ಬ್ಯಾಚ್ ಆಫ್ ಅಂದ್ರೆ ಅವ್ರು ಒಂದು ನಂಬರ್ ಕೊಟ್ಟಲ್ಲ 22 2634 ಆಫ್ 22 ಮೇಡಮ್ ದಾ ಇಲ್ಲ ಒಳಗಡೆ
ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಬ್ಯಾಚ್ ಕೇಸ್ ಇವರು ಒಂದು ಬ್ಯಾಚ್ ಕೇಸ್
ಈಗ ಅವತ್ತೆರಡು ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಸರ್. ಅಕಸ್ಮಾತ್ ಏನಾದ್ರು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅದಕ್ಕೆ ಲಿಂಕ್ ಮಾಡಿಸ್ಕೊತದ್ ಬಿಡಿ ಅಲ್ವಾ. 2 ಕೇಸ್ ಇದೆ ಅದರಲ್ಲಿ, ಬ್ಯಾಚ್ ಕೇಸ್ ಒಂದು 58 ಇದೆ, ಇನ್ನೊಂದು 160 ಚಿಲ್ಡ್ರನ್ ಏನೋ ಇದೆ. ಇದೊಂದು ಮೆಮೋ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ಯಾಂಕ್ ಅವ್ರು, ಅದನ್ನ ಮೇಲ್ಗಡೆಗೆ ಫಿಲ್ ಮಾಡಿ ಸರ್. ಇದು ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲಿ ಏನಮ್ಮ ಸಿಕ್ತು, ಅಲ್ಲಿ ಇಟ್ಕೊಂಬಿಟ್ಟಿದ್ರು ಸಾಯಂ ಮೇಡಮ್. ಅಪೀಲ್ ಮೆಮೋ ಅಲ್ಲಿ ಇಟ್ಕೊಂಬಿಟ್ಟಿದ್ದಾರೆ, ಆರ್ಡರ್ ಶೀಟ್ ಕೆಳಗಡೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು. ಡೀಲಿಂಗ್ ಬರುತ್ತಾ ಇದು ಇನ್ನೊಂದು ಬರೀ ಮೈನಲ್ಲಿ ಡೀಲಿಂಗ್ ಬಂದ್ಬಿಡಿ ಆ ನಂಬರ್. ಇನ್ಯಾವ್ದು ಕೊಡ್ಲಿ?
32 ಡಿಸ್ಪೋಸ್ ಆಯ್ತು.
32, 32.
ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಹಾ
ಪಾರ್ಟೆಡ್ ಆಗಿದೆ.
ಪಾರ್ಟೆಡ್ ಯಾವ್ದು ಹೇಳಿ?
3
ಪಾರ್ಟೆಡ್ 2 and 3 ಪಾರ್ಟೆಡ್ 19 ಮಂಡೇ. ಅದೇ ಇರ್ಲಿ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಹೊತ್ತು, ಸ್ವಲ್ಪ ಇದೆಲ್ಲ ಕೆಲಸ ಇದೆಯಲ್ಲ, ಯಾಕೆ ಇವಾಗ್ಲೇ ಇಟ್ಬಿಡ್ತೀಯಾ? ಒಂದ್ ನಿಮಿಷ ಇದು ಒಂಚೂರು ಒಂದ್ 5 ನಿಮಿಷ ಇದು. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 3, 2, 3 ಮತ್ತೆ 6. 3 ಪಾರ್ಟೆಡ್ 19 ಮೊನ್ನೆ 3 ಸೋಮವಾರಕ್ಕೆ. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಪಾರ್ಟೆಡ್ ಡೇಟ್ ಇಲ್ಲ. 13 ಪಾರ್ಟೆಡ್ ಡೇಟ್ ಇಲ್ಲ. ಆಮೇಲೆ ಇದೊಂದು 19 ಡೇಟ್ ಕೊಟ್ಟಲ್ಲ ಪಾರ್ಟೆಡ್ 31 ಪಾರ್ಟೆಡ್ ಆನ್ 19 ಮಂಡೇ. 31 ಪಾರ್ಟೆಡ್ ಸರ್, ಆಸ್ ಪಾರ್ಟೆಡ್ ಆನ್ 19 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದು CS ಮೇಡಮ್. ಇದು ಇದ್ರ ಜೊತೆ ಒಂದು ಸೆಟಪ್ ಇದು ಕೊಟ್ಟಿದ್ರು ಅವ್ರು, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಾಕ್ಸ್ ಸಹ ಅವ್ನ ಅದು ಎತ್ತಿಟ್ಟಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಇದಕ್ಕೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಾಕ್ಸ್ ಕೊಟ್ಟಿದ್ರು ಅವ್ರು ಅಕೌಂಟ್ಸ್ ಟೂನವರು, ಅದೇ ವೈಟ್ ಒಂದ್ ಮೇಲೆ ಇಡ್ತಿದ್ವಲ್ಲ ಅದು ಎತ್ತಿಡು ಅಂತ ಹೇಳಿದೀನಿ ಅಶ್ವತ್ಗೆ. ಕೇಳಪ್ಪ ಎಲ್ಲಿ ಇತ್ತ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಾಕ್ಸ್ ಇದ್ದು KEB ಅಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದಲ್ಲ ನೀವು ಚಾರ್ಜರು, ಅದ್ರ ಬಾಕ್ಸ್ ಎತ್ತಿಟ್ಟಿಲ್ಲ. ಅದೇ ಇವಾಗ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಾಕ್ಸ್ ಇದ್ರೇನೆ ಇದು ಆ ಕಡೆ ಹೋಗೋದು, ಈಗ ವೈರ್ ಎಲ್ಲೂ ಸಾಲಲ್ಲ, ಯಾವ ಕಡೆ ಪ್ಲಗ್ ಇದ್ರು ಸಾಲಲ್ಲ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬಾಕ್ಸ್ ಅದಕ್ಕೆ ಅಕೌಂಟ್ಸ್ ಇಂದ ಇನ್ವೆಂಟ್ ಆಗಿ ತರಿಸ್ಕೊಂಡಿದ್ದೆ ನಾನು, ಅದು ಎತ್ತಿಡಿ ಅಂತ ಹೇಳಿದೆ. ಓಕೆ ಆ ಪೋರ್ಟಲ್ ಬಿಟ್ಟಿರ್ತಾರೆ, ಎತ್ಕೊಂಡು ಬೀರು ಹಾಕು.
ಇಲ್ಲ ಬ್ರೋ, ಇಲ್ಲ ಅವನು ಮೊನ್ನೆ ನಿಮ್ ಜೊತೆ ಕಾಣಿಸಿದ್ದಲ್ಲ ಅವನು ಅಷ್ಟೇ.
ಯಾವ್ದಿದು ಅಲ್ಲ ಆ ಕಡೆ ಹೋಗ್ತೀರಿ. ಅದು TS ಅಲ್ವಾ? ಒಂದೇ ಒಂದು ಇವಳ್ದೊಂದು ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ. ಸೀರಿಯಲ್ ನಂಬರು 30 ಯಾರಿಗಾಗಿರೋದು ನೋಡಿ. ಅದೇ ಅದೇ ಒಂದೇ ಒಂದು ಇದೆಲ್ಲ. ಒಂದ್ ನಿಮಿಷ ಕೊಡ್ತೀನಿ. 31.1 ಯಾವ್ದೋ ಒಂದು ಅವಳಿಗಾಗಿತ್ತಲ್ಲಪ್ಪ, ಸೀರಿಯಲ್ ನಂಬರ್ 30 180. ಇದು SMC ತೋಡಿ ಸರ್, SMC ಯಾವ್ದು? ವೆಲ್ಲಂಗಣ್ಣಿ ಅದು ಜೆಂಟ್ಸ್ ಇರ್ಬೇಕು ಸರ್. ವೆಲ್ಲಂಗಣ್ಣಿ ನಂಬರ್ 18 ಒಂದು ಅವ್ರಿಗೆ ಕಳಿಸ್ಬಿಡು ಅಂತ ಹೇಳಿದೆ ಸರ್. TS ಕೊಟ್ಬಿಡು ಅಂತ. 18 ಮತ್ತೆ 11 ಇಲ್ಲೇ ಇಟ್ಟು 18 ಒಂದು ಫೈಲ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡು ಬೇಕಾದ್ರೆ. ಹಲೋ ಮೇಡಮ್, SMC ಅವರು ಕೊಡಿ. SM
ಮೇಲೆಗೆ 2 ಪೆನ್ಸಿಲ್, 1 ಪೆನ್, ವಾಟರ್ ಇದೊಂದು, ಆಮೇಲೆ ಇದೊಂದು
ಸೀರಿಯಲ್ ನಂಬರ್ 18.
ಎಲ್ಲಿಗೆ ಬೀರಲ್ಬೇಕಾ?
ಅಲ್ಲ ಮೇಲೆ
ಅದು ಬೇರೆ ಆರ್ಡರ್ ಆಗಿದೆ. ಅವರು TS
ಸರ್ ಮೇಲೆ
18 ಮಾಡ್ಬೇಡ. ಮತ್ತೆ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಒಂದ್ ಸ್ವಲ್ಪ ಇತ್ತು, ಫೈಲಿಂಗ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 2 ಅಂತ. ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಬಿಟ್ರದು ಅದು ಏನು ಬೇಡ 11 ಪಾಸ್ ಓವರ್ ನೀನೇನ್ ಬರೀಬೇಡ ಅದು 18 ಒಂದು ಫೈಲ್ ಅವರು ಕೊಟ್ಬಿಡು ಅವ್ರಿಗೇನೋ ಬೇರೆ ಆರ್ಡರ್ ಆಗಿದೆ ನಿಂತಾಗಿರೋದು ಫೈಲ್ಸು ಟೈಪಿಂಗ್ ಪೂಲ್ ಫೈಲು ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ತೋರಿಸಿದ್ದ ಟೈಪಿಂಗ್ ಪೂಲ್ಗೆ ಎರಡಿದೆ ಚೇಂಬರ್ಗೆ ಅವರು PS ಸೀರಿಯಲ್ ನಂಬರ್ ಇಲ್ಲಿ ಮನೋಜ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಈಸ್ಕೊಂಡು ಇವರು ಕೊಟ್ಬಿಡು ಇವರು PS ಗೆ ಇದ್ರೊಳಗಡೆ ಒಂದು ಮಂಡೇಗೆ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಂಡೇಗೆ ಇರೋದೆಲ್ಲ ಸೈನ್ ಮಾಡಿಸ್ಬೇಕಂತ ಮೇಡಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಂತ ಹೇಳಿ 18 ವಾಪಸ್ ಇಸ್ಕೊಂಬ ಪೂಲ್ಗೆ ಹೋಗಿ ಇವಾಗ ಈ ಫೈಲ್ ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮಂಡೇಗೆ ಡೇಟ್ ಇರೋದೆಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ಸ್ ನ ಇವತ್ತೇ ಸೈನ್ ಮಾಡಿಸ್ಕೋಬೇಕಂತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು